When you add up everybody in this body, there's hardly anybody in this body that can equal the expertise and the experience that he has had, not only as an attorney general in his state, but also as a justice on the Texas Supreme Court. And that's not an easy court to be on. There are real legislative and legal battles in Texas that dwarf some of the other states in this country. And this man is, without question, one of the best additions we've ever had to this Senate. Senator Cornyn is a person who we all ought to listen to. He's had the experience. He knows the law. He's a tremendous lawyer, tremendous judge, tremendous prosecutor, and attorney general who really understands these issues. And frankly, I have a very high regard for him in every way in the law. And when he says that we ought to listen, we ought to listen. I want to thank the distinguished senator for his comments. Madam President, I rise today to discuss the appointment of Elena Kagan to be the Associate Justice of the United States Supreme Court. The Senate's role of advice and consent is a check on the President's power to appoint, not a substitute for it, but a check. At the same time, the Senate's role must be more than an empty formality or a mere rubber stamp. I've examined Ms. Kagan's record. I participated in her entire hearing before the Judiciary Committee, and I have listened to supporters and opponents both in Utah and across the country. I can say this. I've lectured at Harvard when she was dean up at Harvard. She came. I like her personally. I appreciated the way I was treated while I was there. It was clear that she probably didn't agree with some of the things I was saying, but she was courteous and decent. I like her personally. But this is something that is even more important than personal affection. If we apply the standard that I have consistently used for judicial nominees, that standard leads me to conclude that I just cannot support her appointment, as much as I like her as a human being. Qualifications for judicial service include both legal experience, which summarizes the past, and judicial philosophy, which describes the future. Now, two categories of legal experience stand out among the 111 men and women who have served on the United States Supreme Court. 2/3 of them, including every current justice and the justice Ms. Kagan has been nominated to replace, have previously been a judge. The 39 previous justices who lacked judicial experience had an average of 21 years of legal practice. In other words, Supreme Court justices have had experience behind the bench as a judge, before the bench as a lawyer, or both. Ms. Kagan has neither. She was a junior associate in a large law firm for only 2 years. She has never tried a case, never argued before any appellate court before becoming Solicitor General just last year. And I'm sure the reason they made her Solicitor General was to give her some experience so they could do what they've done here in the White House, appoint her, send her nomination up as a justice on the Supreme Court. And though Harvard law students must contribute at least 40 hours of law-related pro bono service as a condition of graduation, Harvard's former Dean Kagan appears to have done none at all. Ms. Kagan's experience is instead academic and political. One of my Democratic colleagues said here on the floor that Ms. Kagan's best qualification, or qualifications for the Supreme Court, are her experience making policy and her ability to build consensus. Now, I, for one, believe that the line between the political and the judicial is already too blurred. While the political or policy mindset focuses on achieving desirable results, judges must focus on following the right process. Without any real experience or grounding in the actual practice of law, Ms. Kagan's experience makes me more, not less, skeptical of her suitability for the Supreme Court. And it puts even more emphasis on her judicial philosophy, which is the second and more important qualification for judicial service. As I said at the confirmation hearing for Justice Ruth Bader Ginsburg in 1993, there must be clear and convincing evidence that a nominee understands the proper role of the judiciary in our system of government. I voted for Ruth Bader Ginsburg, even though I knew that her philosophy was different from mine. Nevertheless, I believe there was clear and convincing evidence that she understood the proper role of the judiciary in our system of government. And what is the proper role of judges in our system of government? One of my predecessors as Senator from Utah, George Sutherland, served on the Supreme Court for 16 years. He distinguished between interpreting the Constitution and amending it in the guise of interpretation. Confusing the two, he wrote, converts, quote, what was intended as inescapable and enduring mandates into mere moral reflections, unquote. These are fundamentally different judicial philosophies that identify inherently different relationships between the judge and the few. The central confirmation question before us today is what kind of a justice Ms. Kagan would be. The answer begins with the president who nominated Ms. Kagan. When he was a senator, President Obama said that judges decide cases based on their deepest values, their core concerns, and what is in their heart. As a presidential candidate, he said that he would appoint judges who have empathy for certain groups. As president, he has nominated judges who believe that they may find the Constitution's meaning in such things as social practices, evolving norms, practical consequences, and even foreign law. President Obama has clearly taken sides in the judicial philosophy debate. Ms. Kagan has identified a general and a specific source of evidence for us to examine. She told the Judiciary Committee generally that, quote, you can look to my whole life for indications of what kind of judge or justice I would be, unquote. And she told one of my Judiciary Committee colleagues specifically that we can learn a lot about her, quote, by seeing how I did when I worked at the White House, unquote. While in graduate school, Ms. Kagan wrote that the Supreme Court may overturn previous decisions because, as she put it, quote, new times and circumstances demand a different interpretation of the Constitution, unquote. She wrote that judges may, quote, mold and steer the law in order to promote certain ethical values and achieve certain social ends, unquote. Ms. Kagan was describing a judicial philosophy guided by moral reflections rather than by enduring mandates. When asked about this thesis at her hearing, Ms. Kagan said, quote, let us just throw that piece of work in the trash, why don't we, unquote. Well, I cannot do that. While every piece of a nominee's record must be viewed in its proper context, I cannot simply ignore whatever may raise questions or doubts about Ms. Kagan's judicial philosophy. It was Ms. Kagan, after all, who told us to examine her whole life for evidence of the kind of justice that she would be. This obviously includes writings such as her Oxford graduate thesis. Writing as a law professor several years later, Ms. Kagan agreed that in most cases that come before the Supreme Court, the judge's own experience and values are the most important elements in the decision. If that is too results-oriented, Ms. Kagan wrote it, so be it. Well, to be candid about it, that is too results-oriented and echoes the same activist approach that Ms. Kagan embraced in her graduate thesis. While Ms. Kagan has not herself been a judge, she has singled out for particular praise judges who share this activist judicial philosophy as heroes of hers. In a tribute she wrote for her mentor, Justice Thurgood Marshall, for example, she described his belief that the Supreme Court has a mission to, quote, safeguard the interests of people who had no other champion, unquote. Ms. Kagan did more than simply describe Justice Marshall's judicial philosophy. She wrote, quote, and however much some recent justices have sniped at that vision, it remains a thing of glory, unquote. Now, Justice Marshall was a pioneering leader in the civil rights movement. I have great respect for the courage and efforts he made as a civil rights leader before going on the court. He blazed trails. He empowered generations. He led crusades. But he was also an activist Supreme Court justice. He proudly took the activist role or side in the judicial philosophy debate. Some on the other side have suggested that honestly identifying Justice Marshall's judicial philosophy for what it is somehow disparages Justice Marshall himself. I assume that this ridiculous and offensive notion is their way of changing the subject because they cannot defend an activist, politicized role for judges. In 2006, when she was dean of the Harvard Law School, Ms. Kagan praised as her judicial hero Orrin Hatch, who served for many years on the Supreme Court of Israel. A brilliant person, no question about that, just like Justice Marshall. Brilliant, but an activist. Orrin Hatch has been described by U.S. Circuit Judge Richard Posner, one of the leading lights in the judiciary in this country, as an aggressively interventionist judge who has, quote, created a degree of judicial power undreamt of by our most aggressive Supreme Court justices, unquote, and for whom, quote, the judiciary is a law unto itself, unquote. Ms. Kagan did not simply describe Justice Hatch's judicial philosophy or praise him as a person. She called him, quote, the judge or justice in my lifetime whom I think best represents and has best advanced the values of democracy and human rights, of the rule of law, and of justice, unquote. My friends on the other side of the aisle try to spin away Ms. Kagan's praise of Justice Hatch by noting that Justice Antonin Scalia once warmly introduced him. But while Justice Scalia said he had, quote, respect for the man, unquote, he made clear that he and Justice Hatch had, quote, fundamental, philosophical, legal, and constitutional disagreements, unquote. Ms. Kagan, in contrast, said that Justice Hatch was her judicial hero and represented the rule of law better than any other judge. Now, it appears that the very first time that she distanced herself from his judicial philosophy was at her confirmation hearing. When she was dean, Ms. Kagan had opportunities to choose between her personal views and the law. Federal law, known as the Solomon Amendment, required that military recruiters have equal access to students as other employers. Harvard protested the Don't Ask, Don't Tell law regarding military service by homosexuals by allowing military recruiters access not through the Office of Career Services, but through the Harvard Law School Veterans Association, a private group with no office, no staff, and no budget. The Defense Department told Harvard in 2002 that this policy did not comply with the Solomon Amendment. Ms. Kagan, who had very publicly denounced the military service law, joined a lawsuit challenging the Solomon Amendment. Within 24 hours of a decision by the U.S. Court of Appeals for the Third Circuit, not her circuit, by the way, in joining it, she again banned military recruiters from the career office, even though the ruling did not apply to Harvard, which is in the First Circuit. In other words, she reinstated a policy that she knew violated federal law, and even kept that policy in place when the Third Circuit stayed its own injunction, recognizing that this was going to the Supreme Court, this case. Ms. Kagan could have opposed the law in various ways, but chose to do so in a way that undermined the military and defied federal law, certainly the federal law of her own circuit. Her personal views drove her legal views. Ms. Kagan also told us to examine her service in the Clinton administration, a period during which she has said she acted as a policy advisor rather than as a lawyer. She was, for example, a key player behind the Clinton administration's extreme abortion policy, including its defense of the barbaric practice of partial birth abortion. In a 1996 legislative strategy memo, she labored as a disaster a proposed statement by a key medical group that there exist no circumstances in which partial birth abortion is the only option for doctors to take. That was the organization representing the obstetricians and gynecologists in America. Well, she drafted and persuaded that group to adopt language with a much different political spin. At her hearing, Ms. Kagan offered the implausible claim that she was merely trying to ensure that the medical group accurately expressed its own medical opinion. In other words, the disaster she identified was a PR disaster for the medical group, not a political disaster for the Clinton administration. Now, that's too hard to believe, especially in light of evidence that Ms. Kagan also sought to persuade the American Medical Association to change its similar conclusion that partial birth abortion is not medically necessary. Now, let's understand what partial birth abortion is, this barbaric practice. It's where they turn the child around, a fully grown child capable of living on its own outside the womb, till its head is coming first. Then they ram scissors or some other sharp instrument into the back of the skull, suck out the brains, then pull the baby out and say it's not a human being. I don't know anybody that should not consider that tremendously offensive and barbaric. Now, political objectives appear to have trumped even medical science. In May 1997, after President Clinton had vetoed the Partial Birth Abortion Ban Act, Ms. Kagan wrote a memo recommending that he support a sham ban offered by Democratic senators that everybody here knew was a sham. She argued that this step might attract votes from senators who otherwise would vote to override President Clinton's veto. And since the substitutes would not pass, and she knew they would not, partial birth abortion would remain legal, this barbaric practice. Whether you're for or against abortion, most people find that practice barbaric. Significantly, however, Ms. Kagan noted that the Office of Legal Counsel had concluded that these substitute bans were unconstitutional under the Supreme Court's Roe v. Wade decision. Now, there's no indication that she disagreed with this conclusion. The point is that Ms. Kagan urged a purely political position on abortion that was at odds with what the Clinton administration then believed the Constitution required. I don't know about others, but that's something that really has bothered me. And I don't think she was forthcoming in that part of the hearing. And there were some other parts where I didn't think she was forthcoming as well. But that one particularly bothered me, as did, frankly, some of the others. Once again, it bothered me because it looks like politics controlled the law. Ms. Kagan's hearing did nothing to temper the activist picture that emerges from her record. She chose an approach to answering questions that was far different from what she once argued was necessary for the Senate properly to evaluate nominees and educate the public. I asked 3 times, for example, if she had written the 1996 memo I discussed a minute ago. Mind you, the memo has her name on it and includes a page of her own handwritten notes. After 3 tries, Ms. Kagan would say only that it was in her handwriting, which I suppose leaves open the possibility that it was forged. It was certainly her prerogative not to give senators anything meaningful during her hearing, but it leaves the rest of her record as the basis for determining what kind of a justice she would be. Other senators will discuss in more depth some of the additional troubling issues raised by Ms. Kagan's record, some of which I agree with as issues. These certainly include positions she has taken and arguments she has made that signal a sweeping, unprecedented view of federal government power. At the hearing, for example, I questioned her about the troubling position she took before the Supreme Court in the Citizens United versus FCC case. She argued that the First Amendment allows the federal government to determine who may say what, when, and in what manner about political candidates. Well, I think the First Amendment rights of free speech go way beyond what she said. She argued that the government may ban certain print or electronic books, movies, and even pamphlets that mention candidates close to an election. Yeah. What about that First Amendment? What about the right to free speech? Political speech is among the most protected by our Constitution. Yet she said government could ban certain print or electronic books, movies, and even pamphlets. I wonder what Paine would think about that. Of course, he's been long gone since Revolutionary War days. She argued that the government may silence unions, for-profit corporations, non-profit groups, and even tiny mom-and-pop businesses if they organize legally as a corporation. Thankfully, the Supreme Court sided with freedom of speech. As if that breathtaking degree of federal power were not bad enough, Ms. Kagan also worked in the Clinton administration to weaken and limit other individual rights, such as the Second Amendment right to keep and bear arms. And in her hearing, Ms. Kagan refused to acknowledge any real limits on the federal government's power, which the Supreme Court has already expanded far beyond anything America's founders intended, to regulate everything imaginable in the name of interstate commerce. I guess Article 1, Section 8 of the Constitution. I'm going to summarize for a minute here. Ms. Kagan's academic and primarily political experience make critical the need for clear and convincing evidence that she is committed to the proper role of judges in our system of government. The critical confirmation question is the kind of justice Ms. Kagan would be. Will the Constitution control her, or does she believe that she may control the Constitution from that hallowed position as a Supreme Court justice? Looking where she directed me to look, I believe the evidence shows that she embraces an essentially activist view of judicial power. This is a grave decision that we have here in the Senate. It's about more than simply one person. The liberty we enjoy in America requires that the people govern themselves, and that in turn depends upon the kind of justices who sit on the highest court in the land. George Washington said this in his farewell address, quote, "The basis of our political systems is the right of the people to make and alter their constitutions of government. But the Constitution, which at any time exists till changed by an explicit and authentic act of the whole people, is sacredly obligatory upon all," unquote. That was George Washington. Judges who bend the Constitution to their own values and who use the Constitution to pursue their own vision for society take this right away from the people and undermine our very liberties themselves. As you can see, I'm very worried about this nomination. I had never voted against a Supreme Court nominee before when I voted against now Justice Sonia Sotomayor. I did not think she was forthcoming on a number of issues. And I've been proven right in a number of instances, and let me just mention one. She basically said the Heller case on the right to keep and bear arms was settled law. Now, settled law to a lawyer means it's law that you shouldn't overturn. It's law that exists that must be followed. Shortly after she was within a year or so on the bench, she voted in a case to overturn the Second Amendment. Now, I hope I'm wrong about soon-to-be Justice Kagan. I hope that she proves me wrong. I hope that the great legal mind that she has and the abilities that she has will be put to great use in upholding the Constitution, not tearing it down, or not modifying it without constitutional justification. I hope that I'm wrong. I hope that she will be a great justice on the bench by following the Constitution by resolving issues in accordance with constitutional precepts, and by doing what the Founding Fathers expected all justices on the Supreme Court to do. And that is not substitute their own predilections for what the law, for what the Constitution really is. I hope with all my heart that I'm wrong. But like Justice Sotomayor, I just think there's enough evidence, indications about her judicial philosophy that I'm probably not going to be found wrong in the coming years. I hope I will be. I'll be the first to admit it. I'd be overjoyed if she proves me wrong in the criticisms that I've lodged here today. This is nothing personal to me. I personally like her. I personally think she's a brilliant woman. I personally think that she's a great dean at Harvard. But I'm very concerned about the issues that I've raised here today. Mr. President, I suggest the absence. Mr. President, I yield the floor.
Mr. President.
Senator from Ohio.
Mr. President, I ask unanimous consent that the three